Hello, this is John Milburn, Laws 19038, Planning and Environment Law. This week we are talking about the role of the Commonwealth in environmental law. I have prepared a dedicated Zoom session in relation to that, and I'd ask that you please consider that. I thought I might take the opportunity to discuss a bit of planning law, and in particular refer you to certain parts of the Sustainable Planning Act which you should be aware of in a general sense. I think the Act is one where you can start to delve in and work your way around the Act, making your way from one section to another. So what I'm really talking about tonight is some guidelines to help you get started in that process. And I'd like to talk to you about the approval process of a development. So under the Sustainable Planning Act, if you look at section 240, you'll see that there are essentially four types of approvals available to developers in relation to applications. Now, the first two are development approvals, and the third and fourth rather, are compliance issues. So the first two, which are both development approvals, are preliminary approvals and development permits. And you can see that those two types are referred to in Schedule 3 to the Act. The other two, which are again referred to in section 240 of the Act, are compliance permits and compliance certificates. So they're the different types of approvals that are available to be obtained and refer to the Act. As a guide, always go to the Act first and work your way through that. So let's talk briefly about development approvals. As I mentioned, they're the two types, the preliminary approval and the development permit. Have a look at sections 241, sections 238 and 578 in that regard. And the reason I mention those sections is that you will see that an application for a development an applicant for a development may choose whether or not to apply for that preliminary approval. That's an optional thing. However, a development permit will always be required for what we call a code or impact accessible development. And have a look at the definitions in the sections that I've referred you to. There are some important consequences that flow as a result of whether or not a particular application is code accessible or impact accessible. All right, so a preliminary approval, of course, provides some indication as to whether the accessible development can be approved. But the development approval, or the development permit rather, which is the second type of approval, actually authorises the work to take place. And there's no surprise in the definition of there. All right, I might then refer you to the issue of the third and fourth type of approvals, compliance permits and compliance certificates. So the compliance stage of IDAS enables the development to proceed or documents or works to be undertaken for those to be assessed for compliance against various regulations and planning instruments and approval permits. Now, have a look at section 393 of the Act in that regard. If you then look to Schedule 18 to the Sustainable Planning Regulations, you'll see that a development which falls within that schedule no longer requires a development permit, only a compliance permit. Now, this is where it gets tricky. When you're involved in a development or you're advising a developer, you need to be aware of these basic types of approvals and have a basic idea of when the approvals apply and when they don't apply. What we don't want is for your client to go off spending thousands, maybe tens of thousands of dollars in applying for a particular approval which may not be necessary in the circumstances. So you need to be aware of the types of approvals and when they may or may not be necessary. So a compliance certificate approves the documents or the works which are under consideration. Have a look at the Sustainable Planning Act section 395 in that regard. Now, a compliance permit, as opposed to a certificate, actually authorises development to proceed. Now, I mentioned, or I should have mentioned, that there are some deeming provisions. The Act provides that in certain circumstances there will be deemed approvals. Have a look at Chapter 6, Part 5, Subdivision 4 in that regard, where particular types of code-accessible developments applications will be deemed to become approved in certain circumstances. So if the assessment manager fails to make a decision within a period of time, then that code-accessible development application will be deemed to be approved. Now, again, the reason for this is important is if you're advising a client in relation to a matter, you need to be aware of when there will be a deemed approval, and you need to be onto it so that you're ahead of the game, letting the client know, for example, that by a certain date, if we don't have an assessment manager response in the appropriate form, then it will be a deemed approval. So everybody knows where you're going with those things. All right, I'll get you to read generally through sections 242 and 295, which deal primarily with IDAS procedures. We talked about IDAS previously, so that might provide you with some assistance and some guidance there. Now, it may be, throughout this whole process, necessary to make an application to a court so that you can seek a declaration. A declaration is something which is available to courts at certain levels. It's not available in every court. It's not available in a magistrate's court, for example. And it's what we call an equitable order. An equitable order or a declaration is a statement by a court as to the law in a particular circumstance. So it may be necessary to keep that in mind, keep that armoury to apply for a declaration before the Planning and Environment Court in certain circumstances should the need arise. So there may be, for example, ways in which preliminary approvals can be considered through a declaration as to whether or not a particular circumstance does or does not apply. All right, so the first part that I've been discussing tonight really relates to approvals, and as indicated, there's the 4 types. Have a look at section 240 of the SPA. That's the starting point. I'd like to talk briefly about conditions as well. In that regard, have a look at section 324, and you'll see in that section that assessment managers, which are primarily people involved in the council, have the power to provide approval to developments subject to conditions. Now, this is where most of the litigation comes into effect. The conditions that are imposed may be so onerous that it's in fact a denial of the application, and proceedings can be brought before the Planning and Environment Court to challenge those conditions or some of those conditions. So have a look at Chapter 6, Division 5 of the Sustainable Planning Act. That will provide you with some outline of the specific requirements that are required for all development, or for all conditions imposed in development approvals, and Section 346 states that some matters may contain certain things. So there's a list there of things that might be contained in conditions, and of course, if you're giving advice to a developer or you're advising an assessment manager, then you need to be aware of what the powers of the assessment manager are to impose conditions and try to structure your advice in relation to comparing what is there or what's proposed compared to what is allowable under the Act. And so the starting point is you've got to know what is allowable by way of a condition in the Act. Have a look at section 346 and 347 of the Sustainable Act in that regard. 346 will say these are the things that may be contained. Section 347 will provide a list of the things that cannot be contained or are prohibited. But generally speaking, conditions need to be relevant and they need to be reasonably required, or either of those. So have a look at section 348 in relation to that aspect of it as well. Section 345 of the Act talks about what is reasonably required in a condition. So the test of reasonableness or relevance is stated in the section itself, and what that does is reflect what had been discussed at common law and what is relevant in the common law sense. So For example, the condition has to really relate to the development application which is before it. It has to be reasonable to the degree where it can be complied with. And of course, whenever you're considering whether or not a condition is reasonable, you need to be aware, of course, that a condition can't be imposed for what we call an ulterior motive. So it can't be imposed for some other purpose. So have a look at section 345. That in particular will give you some good guidance as to what might be regarded as reasonable and relevant. And in particular, don't forget to use the note-up facility. I'm referring now to Ostly. And if you use that note-up facility when you're in the section, you'll see reference to a number of relevant cases. And some of those cases talk about the balancing act, which is relevant when discussing conditions generally. All right. Finally, I'll just talk about infrastructure charges and conditions. And the Act does provide for these conditions to be imposed in certain circumstances. So there are some guidelines there that you might need to look at. Have a look at sections 627, 628 of the Sustainable Planning Act, and you'll see some of those things that relate to the priority infrastructure plans. All right. It's only intended to be a brief overview tonight. I think that'll get you started. The idea of what I want you to do is have a look at the Act, look at the specific legislation, look at the sections, try to make some sense of it, and work from one section to another so that you've got those key points firmly in mind, make some summaries of those, and that way you'll be able to advise your clients in a more direct and beneficial way. All right, so as mentioned, the prescribed reading for this week is Chapter 5 of Bates. Very briefly, you'll see in that the Commonwealth gains its power through the Constitution, and it has certain power, exclusive power in relation to certain things, such as sections 90 and 92, which deal with certain powers to have the ability to make laws in relation to customs, duties and excise, and section 92, which deals with guaranteeing freedom between states. Then, of course, there's the Commonwealth Places legislation, section 52 of the Constitution, which means that the Commonwealth has power to make laws in relation to the to Commonwealth places. And bear in mind that where there's a conflict between laws, that the law of the Commonwealth will apply in priority to the law of the states. Now, having said all that, the odd thing about the Constitution is that the Commonwealth has power in relation to certain specified things. It doesn't have power generally. States effectively have this power to make laws generally, and they all have power to make laws in relation to things which are referred to in the Constitution. It's just that the Commonwealth has that power, and if the Commonwealth chooses to make a power, even though the states might, as we've identified through section 109, the Commonwealth power will prevail. So if we think about environmental law as being something which is newly created, only 40 years old, then of course it comes as no surprise to realise that in 1900, when the Constitution was prepared, there is no reference to the Commonwealth having power to make laws in relation to the environment, because environmental law just wasn't considered. We talked early on about the common law and the fact that environmental law had to create through statute ways of getting around the common law and common law rights. But that creates some interesting circumstances. In Chapter 5, Bates refers to a number of cases which highlight the way in which the Commonwealth was able to use what power it did have in the Constitution to effectively create environmental laws without calling them environmental laws. So, to my mind, one of the very early important cases is the case of Murphy-Oars against the Commonwealth. Murphy-Oars case, which is 1976, which is really at the vanguard, at the start, if you like, of the environmental law movement. And in that case, the Commonwealth was able to make laws to essentially refuse to grant an export approval for mineral sands from Fraser Island. They did so on environmental and social grounds, but they didn't have power to make laws in relation to environmental and social grounds, but they did have power to make laws in relation to trade and commerce. So they used that trade and commerce power as the way in which they could effectively prescribe environmental law sanctions. Likewise, in the external affairs powers, the Tasmanian Dam case, now we've moved from the 70s with Murphy Oars to the 80s for Tasmanian Dam, and in that case the Commonwealth was able to use its external affairs power to essentially ensure that the dam on the Gordon River did not proceed. And of course that created huge publicity at the time. Many people were arrested, etc. And then we see from the 70s through the 80s a succession of cases where, if you'd like, the states tested the Commonwealth's ability to make laws. These constitutional challenges were overwhelmingly in favour of the Commonwealth, so the states got beaten up quite a lot. And what we found then is, through the 90s, the Commonwealths and states started to cooperate to a much greater degree. And as a result of that, the COAG agreement in 1997 ultimately led the way for the Commonwealth to pass the Environment Protection and Biodiversity Conservation Act 1999, EPBCA, and that really couldn't have happened without the cooperation of the states, because, as we know, the Commonwealth has no power to make laws in relation to the environment, and here it is, a Commonwealth making law that says Environment Protection and Biodiversity Conservation Act. One of the ways they did that was to rely upon their external affairs power. So the external affairs power is also referred to in Bates, and that's the way in which the Commonwealth is able to say, well, look, we have power to make laws that relate to our international obligations, and our international obligations, which are contained in treaties, etc., enable us and require us to make these domestic laws, even though they are environmental in nature. All right, other than that, I just want to draw your attention more specifically to this whole section which deals with the acquisition of property on just terms, and the fact that you need to get your head around the difference between what is property in a legal sense and what is really a permissive right, such as a license. But I go into much more detail in that in the other Zoom video, which I've uploaded for this week. Okay, thank you very much for listening. I hope you're enjoying the course. I look forward to some lively discussions in UCrew, and if you have any problems, send me an email and we'll see if we can resolve them. For now, all the best. Bye.